Good day. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute, and today we have an update on bankruptcy cases in the U.S. Supreme Court. There are 3 cases on the docket for the term that began in October and will end in late June. The first of those cases was argued in early January. That will tell us whether or not the Federal Fair Debt Collection Practices Act applies to non-judicial foreclosures. On February 20th, we have the argument in the second case, which will tell us whether or not rejection of a trademark license bars the licensee from continuing to use the mark. And then sometime, likely in April, the court will hear the third case, which will tell us whether or not good faith is a defense to an allegation that somebody violated one of the automatic stays in bankruptcy, such as that in 362 or the discharge violation. And I want to report to you that on January the 14th, 2 certiorari petitions were filed in bankruptcy cases, and one of them in particular raises an issue that the Supreme Court very much should answer. This new petition is in a case called Davis versus Tyson Foods. And it has to do with, well, really, the question is, how automatic is the automatic stay? And here is how the case or the situation usually arises. Let's say that someone's car has been repossessed by the lender before that person files a Chapter 13 petition. Now, in most circuits, all the debtor's got to do is to write a letter demanding the return of the auto, and that lender must give the auto back. If they don't, the lender will be held in contempt. However, the 10th Circuit and the District of Columbia circuits held to the contrary, and the 10th Circuit case is the one that is coming to the Supreme Court right now on certiorari. As I said, it has to do with whether or not you have to take some action before the automatic stay applies. The 10th Circuit said, well, merely doing nothing is not an action, and therefore does not violate the automatic stay. The Davis case out of the 10th Circuit is not the best conceivable vehicle for certiorari on this issue. However, the perfect cases are now on a consolidated appeal in the 7th Circuit. The last brief in those cases will be filed on February the 19th, and this has to do with the city of Chicago, who has, I got to tell you, gotten very tired of having to give back cars that have been impounded for failure to pay parking tickets. And I can guarantee you, as sure as God made little green apples, that if the city of Chicago loses in the 7th Circuit, they're going to file a certiorari petition. But the way things go in life, that's not going to happen until sometime summer, perhaps next fall. But those cases out of Chicago really do present the issue in a pristine fashion. Well, one way or the other, I certainly hope that the U.S. Supreme Court tackles this issue, and this will really help out creditors and debtors alike to know whether non-action is a violation of the automatic stay. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will be back same time next week with something new and interesting in the area of bankruptcy law. Till then, be well and don't work too hard.